Hi, my name is Brianne Coffey. With Zachary Schuller and Taylor Artis, we are the Venus Group. Our case study review is about student right to privacy. For our presentation, we will briefly outline the scenario, name the problem or problems, critically analyze the situation in the context of relevant laws, policies, and/or theories, perspectives covered in the course content, identify potential strategies for addressing the problem or situation that are legally sound and grounded in policy and appropriate governance expectations, and explain the approach to implement, providing a thorough rationale for doing so. In this case scenario, the role and responsibilities we have as the coordinator of civic engagement at Dewey State University, DSU. This institution is located in Indiana, and our responsibilities are fostering students' civic learning and responsibility through collaboration with student organizations, individual students, course instructors, and community agencies. Our role reports to the director of the DSU Memorial Union. For some context, we've been serving as an interim advisor to the Bulldogger Connections BC group, a recognized student organization with about 120 members divided into student newspaper, student radio station, and social media. Typically, this organization is advised by another colleague. However, when this colleague went on sabbatical, we reluctantly took over the role as advisor. Our approach as an advisor is hands-off, and this is due to our belief in students running media outlets because they have demonstrated strong leadership and they've needed minimal support. The incident that occurred in the scenario was that the BC president reported a violation of privacy. Their dorm room was searched without consent by university police, resulting in the discovery of drug paraphernalia and marijuana. The police also found an electronic taser in the student's vehicle. The student was charged with weapon and drug possession and claimed their constitutional right to privacy was violated, and they intended to sue the university. This scenario escalated. Over the weekend, the students' parents left a voicemail demanding information on university policies. We were instructed by our supervisor to call back, but this raised concerns because we wanted to protect student privacy. The student organization criticized DSU's police department on social media for the unlawful search, leading to pressure from our supervisor to manage the organization. The exec board of BC informed us that they had a plan to protest the 1 week after the search. The administrative response included the dean of students informing us of a demand letter from the student's attorney alleging privacy violations and disclosed that the student would be proceeding through the conduct process for code violations. A guest editorial in the newspaper asserted that the universities cannot search resident halls, spaces, or vehicles. Social media activity continued involving BC other student organizations and individual students raising their voices regarding this situation. Currently, in our role, we're under pressure. We received a message from a supervisor relayed from the president indicating concern from a Board of Regents member about student privacy. President Bartels of the university demanded that we have immediate resolution. With our boss attending a national convention and leaving us in charge, we are facing pressure from both the supervisor and DSU president to address the situation. In this case scenario, there are numerous problems. On top of our supervisor leaving to attend a convention, which puts us in charge, We are facing scrutiny, pressure, and high expectations by the university president and the board to effectively resolve this issue in a timely manner. One of the key problems in this case is that the student president claims their dorm room and vehicle were searched without consent, leading to the discovery of illegal drugs and taser, and they assert that their Fourth Amendment rights were violated. The Fourth Amendment states the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. This raises significant legal issues regarding the constitutionality of the search and the admissibility of the evidence found. If the search is deemed unlawful, it could lead to legal repercussions for the university and impact the students' charges. Another problem, the student is facing charges for possession of illegal drugs and a taser. These drug and weapon possession charges have serious legal and academic consequences for the student. The university must navigate the legal process while upholding its policies on drug and weapon possession, which affects campus safety and the student's future at the same time. The third problem, the students' parents have demanded information about university policies and procedures, which creates a dilemma about what can be disclosed without violating FERPA. FERPA protects the privacy of student education records, and disclosing too much information without the student's consent could result in legal issues for the university. It is necessary, but it's challenging to balance transparency with privacy. Another problem, the fourth problem we saw, is that the student organization has publicly criticized the university police on social media for violating the president's privacy, leading to widespread campus and community outrage. This public backlash can damage the university's reputation and credibility. However, it can also escalate tensions on campus, potentially leading to unrest and further protests. The fifth problem, the student organization has put out an editorial in the newspaper. It claims that the university cannot search residence halls, spaces, or vehicles, potentially this spreading misinformation. And misinformation can influence public opinion and student beliefs, complicating any efforts to address the situation legally and factually. This undermines the university's efforts to communicate its policies and legal standing accurately. Now, this next one is not necessarily a problem. The student organization plans to hold a protest against the university's actions. However, we know that the protests are a form of freedom of expression. How they can disrupt campus operations and escalate tensions if not managed properly. The planned protests could be a problem if it violates campus policies, if it's not conducted peacefully. And last but not least, the university received a demand letter from the student's attorney indicating the intent to sue for the alleged violation of privacy. This legal threat poses potential financial and reputational risks to the university. It requires careful legal handling to protect the university's interests while addressing the students' grievances. These problems are interconnected. Each are contributing in a complex situation. They involve legal, administrative, and public relations challenges that require coordinated and comprehensive response to resolve effectively. And if we're under pressure failure to address any of these issues adequately could worsen the other issues, leading to greater liability, legal liability, administrative difficulties, and potentially damaging the university's reputation and campus climate.
For our analysis of the situation, there are a variety of things that stood out. While the Fourth Amendment does mention the right to be secure in one's home against unreasonable searches and seizures, the rationale for searches in dorms isn't as clear. Legal opinions have varied over the years regarding the issue of if a person's dorm could be considered their home. One example of a legal opinion regarding the issue of students' rights in dorms can be seen in the legal opinion in People versus Cohen. In their legal opinion, the court found that to suggest that a person who lives off campus in a boarding house is protected, but that one who occupies the dormitory rooms waives his constitutional liberties is at war with reason, logic, and law. So while this court case is a little more dated, the legal rationale is important context, as it does give a good example of a legal decision, really just showing when a court found, really examined the issue of what rights does a student have living in a dorm and how that relates to the rights of a person living in a more permanent residence, such as a house that they own. So while students can assume that they have a reasonable expectation of privacy in dormitories, various circumstances can affect the constitutionality of a dormitory room search. So according to law professor Richard Fossey, one of the primary factors that could affect this is the motivation of those searching the dorm room. For example, did they enter a student's room in furtherance of the institution's legitimate interest in preserving health, safety, and an educational atmosphere, or are they pursuing a criminal investigation? So in this case, study involving Dewey University, either argument could be made regarding the intent of the police who entered the student's apartment. The case study is also not clear on whether the police involved are city or campus police. In the case study, there are also not specific policies or procedures listed regarding what Dewey State University has in place. So in a legal context, knowing these policies and procedures for the school's housing department are especially important, as it could really impact the decision that is made in response to this case study and the outcome of a potential lawsuit. Some other important questions to consider are, does Dewey University have housing policies regarding under what circumstances university employees or police can enter a student's room? And also, did the student's housing contract contain language regarding searches and seizures? So this court case right here, State of Washington versus Chrisman, is a little bit older court case. However, it is very applicable to this case study and does have some very important insights. So in State of Washington versus Chrisman, the defendants are Overdahl and Chrisman, both freshman students living in Orton Hall at Washington University. In this case, Overdahl was leaving their residence hall with a half-gallon of gin when university police officer observed them with the half-gallon of gin. The officer immediately suspected that Overdahl was under the age of 21, so the officer requested Overdahl provide identification. Overdahl stated that they would go to their dorm to retrieve the identification. The officer then stated that they would accompany Overdahl to their room. So the officer stood in the doorway of Overdahl's room while Overdahl was retrieving their identification. During this time, while they're standing in the doorway, the officer observed Overdahl's roommate, Chrisman. After watching them for a few minutes, the officer observed seeds in a small pipe lying on a desk about 8 to 10 feet from where the officer was standing. The officer recognized the pipe as a type of marijuana and proceeded to examine the seeds in the pipe more closely. After concluding that it was marijuana and that the pipe smelled of marijuana, the officer gave the students their Miranda rights and indicated to both students that made sure that both students understood their rights and asked if they would be willing to waive them, which the students both consented to do. Subsequently, the students were charged with possession of marijuana, and both students decided to file a case against the university claiming that their constitutional rights had been violated. This case resulted in a series of court cases. In these court cases, a number of questions were examined. The first is whether an individual validly under arrest may be accompanied by the arresting officer into another area without a warrant. In this case, in answer to this question, the court decided that the officer did have that right, as prior case precedent to support this. And then a second question that was examined is exigent circumstances. So, assuming the officer was standing outside the premises, the observation of contraband in plain view constitute exigent circumstances which then permit the officer to enter the premises. So in their ruling, the Washington Court of Appeals upheld a lower court ruling finding that the officer's warrantless entry into Overdahl and Chrisman's room did not violate the Fourth Amendment protections against unreasonable search and seizures. In their decision, the court also upheld the finding that the officer's entry was justified as it constituted exigent circumstances. So the Ninth Circuit Court has defined exigent circumstances as circumstances that allow law enforcement officers to enter a premises without a warrant under the following criteria: an immediate threat to safety, the destruction of evidence, or the pursuit of a fleeing suspect. So while this definition from the Ninth Circuit is a more recent definition, the rationale and the determination that the Washington Court of Appeals used with this doctrine is very similar. So, State of Washington versus Chrisman was appealed multiple times, eventually overturned. However, it is a good example of legal rationale that could be used regarding illegal drug possession and students' right to privacy. So the circumstances of this ruling also differ from the case study. However, the school in this case study, Dewey University, could argue that this situation constitutes exigent circumstances as they feared that the student was endangering other students through their possession and possible distribution of illegal drugs. The school could also argue they feared the student would have destroyed the evidence if they had not acted sooner. So all these arguments are just possibilities. There's a very strong possibility that these wouldn't necessarily hold up in court. However, these are possible routes that could be taken in response to this. So Looking at state and federal laws, currently in the state of Indiana, marijuana is illegal. Another important law to consider is the Drug Free Workplace Act of 1988. So this is a federal law, and it states that in return for receiving grants from federal agencies, federal contractors must take steps to create a drug-free workplace. So as recipients of federal aid and federal grants, universities also fall under this criteria. State and nationwide data suggest that universities are seeing an uptick in marijuana use. As public institutions of higher education, universities do have a responsibility to maintain a drug-free work and school place. In one way, in particular, that can be seen through this case study that universities have attempted to do this is through utilizing campus police. Another important issue to consider in this case study is FERPA compliance. Educational institutions must protect the right of the privacy of student education records. They cannot disclose personally identifiable information without consent. And although parents demand information regarding their children, FERPA restricts what can be shared unless there is a health or safety emergency. Another very important consideration are free speech considerations. So the students' protest and social media activities that are mentioned in this case study are protected under the First Amendment. Universities must be cautious in regulating free speech, as they need to ensure that they do not infringe on students' rights while also maintaining order.
Okay, so this is a lot of information, but you really don't need to read it all. What we really want to emphasize here is that we attempted to look into some university policy and procedures for this fake institution. But so if they're in Indiana University system, we looked to Indiana University for kind of some guidance and outlines of policies that are already in place. So Indiana University, I'm sure you all heard of it before. Indiana University Bloomington is the flagship school. Very large. So they are an alcohol and drug-free. They have an alcohol and drug-free campus policy, which basically says that they're in compliance with the Drug-Free Workplace Act of 1988. So basically, university has to do its due diligence to ensure that their workplace is drug-free. So specifically on this university campus, the unlawful manufacturing of distribution, dispensation, possession, or use of a controlled substance is prohibited on a university campus, which I'm sure is not a surprise to any of you. So with being consistent with local, state, and federal laws, Indiana University policies and procedures as well, IU can and will discipline students and employees who violate this policy up to expulsion, termination of employment, and referral for prosecution. So, or even a rehab program. So, things to note. We think that reviewing the university's code of conduct and housing agreement for specific clauses on searches can clarify the institution's standing. So, again, Dewey State is not real. We think though that their university should review their code of conduct and housing agreement. And policies regarding protests and the use of campus spaces should be revisited to ensure they're followed appropriately during student demonstrations. So here are 3 policies that IU, the very real IU, does have in place that relate to some of the issues that we are discussing. And so perhaps us in our system, legal, might look to these already in place policy and procedures when deciding how to address that or this situation, which we will talk about some ideas that we have coming up next. All right, so at this point in the presentation, you are probably like, this is a ton of information. What are you actually going to do in practice? Well, we have some potential strategies that we came up with. Some of which we have seen utilized in other spaces when negative things have happened in higher education or institutions. Some of which we came up with. I'm sure they're not novel in any way, shape, or form, but some of which we came up kind of based on just our specific scenario. So our first suggestion or strategy is to do nothing, to kind of wait for the situation to die down. A lot of times these kind of headline breaking might be a little extreme, but like these really big situations that happen and are at the forefront of the news and of people's minds at an institution, if nothing really happens, they do start to quiet on down. So the first thing that kind of comes to my mind is Joe Gao. That was huge. And then now you kind of have to look into what's happening in that situation unless you're following really closely. Our second strategy is to, as quietly as possible, settle monetarily with the student and their family, obviously willing to get system or university legal involved to create a settlement agreement with the student. In that, it would be up to the student if they want to remain at the university or want to leave the university after this situation, but they would be provided some kind of financial compensation for our role in the situation, in exchange for no longer participating in any media interviews or anything like that. So the terms of their side would be that they kind of stop speaking about this situation. We as an institution could involve our communications department and participate in interviews and communicate the role of on-campus police and the negative impacts of drug use. So kind of explaining why this situation happens, really reinforcing the positive impact that police can have on campus, and our purpose in trying to kind of decrease the drug use that's on campus. So earlier in the presentation, it was cited about the uptick in the bell curve that is seen in marijuana usage, and just re-emphasizing that, we're doing our part to try to address drug use or marijuana use on campus. Another strategy is to request that the student group not protest and let them know that there may be consequences if they choose to move forward with the protest. Not a great idea. Like, not, one that we have, what we're kind of thinking with this one is seeing the Israel-Palestine conflict protests that are happening on higher ed institutions right now or earlier in the year. Some of those protests have been very heavily impacted and controlled and restricted. So kind of sort of aligned with what we've seen there. And then our last potential strategy is to meet with all important parties involved to develop a mediation strategy and a policy review that was involved in this situation. So you got to see all of our ideas, good and not so good, but here's what we're actually going to do. And this is a multi-step process, but we believe that each individual step really is important to the entire process and making sure that we are supporting all parties involved. So our first step is going to be, right away, we're contacting University Legal Counsel for their opinion and to review the search's legality. We're going to meet with the student body president and the executive board, fully hear them out, right? They have the right to speak. They have the right to be heard. We're going to listen to all that they bring to the table and let them know that we'll be reconvening and following up with them at a later time. We're going to place the officers that were responsible for the search on immediate administrative leave while we get the situation investigated. As far as communication goes, we'll respond to the parents. Obviously, because of FERPA, we can't give details, but we'll explain general policies that the university has in place. We are also going to draft a message to the student body addressing the situation and letting them know essentially that we're looking into this, and we will have further information at a later time. So collaboration and mediation. We're going to set up a meeting with University Police, Dean of Students, and then the Student Group Executive Board. We feel like those are the most important players in this situation. And then we're going to offer mediation services to resolve the conflicts between the police and the student organization. We want the students involved to know that the police are hearing what they're saying, not just us as staff, right? But that the police, who they specifically directly have the grievance with, that they're listening as well. Dean of Students getting involved as a support resource for the students directly, and also we're kind of unsure of the university, since it's fake, structure, but at my institution, I do believe that the Dean of Students and the chief of police are supervised by the same person, so those might be good people that need to be in the room together also. Reviewing and reforming the policies. So immediately, or after this situation, we're going to start a review of the current policies that our institution has in place on searches in residence hall rooms and vehicles. This is important. And as we looked at last week, a lot of these policies are written years and years and years ago, and that's kind of it. So we need to look at okay, what is this policy? Why is it in place? What are we really doing here? Establishing a group including students, staff, and faculty to recommend policy improvements and enhance transparency, and then improving our language in the housing contract regarding students' rights to privacy and defining exigent circumstances. So students understand that there are situations in which university staff and university police can enter your room, and here are what we define as those. Maybe not limited to as what the list is, but just so they have a better idea of what that should look like. As far as the protest goes, we're going to inform the students about policies, remind them about policies around protests, but support their First Amendment right. Our main focus is safety and order on campus. They have the right to protest whatever they want as long as they are following within the university bounds of protest. Then we're going to use the protest as an opportunity to start a dialogue about this situation. A controlled one, maybe necessarily not still continuing to focus on the possible misconduct of the officers there, but really to spark a conversation about what is this policy, what is its purpose, what are the limitations, that kind of thing, just really to inform everyone involved in the student body. And then long-term considerations, we would definitely want to consider developing workshops on students' legal rights and university policies, just a good refresher or a beginning portion for new staff and faculty at the university. We're going to strengthen the role of the advisor in student organizations. I guess myself or us as the advisor we were very hands off, as it was stated in our case study, in our advisor role. So really kind of, reinforcing what our role is, becoming more involved, not micromanaging, but being more hands-on with the situations. And then improving the training of university police regarding room searches and car searches. Whether or not this search is deemed constitutional violating the rights to privacy, yada yada, it was handled poorly. And so improving that training will hopefully help ensure that situations involving searches are handled differently in the future. So why did we decide to handle it this way? We really feel like by addressing the legal issues, facilitating communication, and taking proactive measures to review and potentially reform the policies that we have in place, Dewey State can navigate the situation as best as possible to uphold students' rights, support them through this situation, and maintain institutional integrity. And here is a look at the references that we used for this presentation. Thank you so much for watching.